Before I introduce our presenters, I have a few housekeeping items to mention. We're recording today's program. During the presentation, all participants will remain in listen-only mode. We'll be circulating the material as well as the recording in the days that follow the session. If you experience any technical difficulties, please send a message via the Q&A panel, which is located in the lower right hand of your screen, and ask for assistance from the host. This will be picked up by our IT support team. We've scheduled some time to answer questions at the end of the session. Please use the Q&A function and select all panelists to ask a question directly to our team. If we're unable to answer your questions due to time constraints, we'll follow up with you shortly afterwards. We'll be offering continuing education credit for this webinar. Stay tuned until the end of the program when we will provide you a code to use to obtain credit. This is the second in the series of AI webinars presented by SPB. Next month, we will focus on AI in Europe. To stay informed on AI issues and webinars, subscribe to our privacy blog. Next slide, please. We have three presenters today representing our Berlin, New York, and Los Angeles offices. Next slide. Squire's global data practice is throughout the United States, Europe, Middle East, Africa, and APAC, representing all of the 20 territories that in which we practice. And we are spending a lot of time in AI in all of these, and we're going to try to talk a little bit about the different territorial approaches to AI today, but we're going to have focus sessions on each region coming up. Now, without further ado, I turn it over to Julia and Annetta to get us started.
Thank you, Alan, and thank you to everyone who's attending, and also to our wonderful webinar support team who makes this all possible and very easy for us. So a big shout out to them, and to my two wonderful colleagues who very patiently agreed to do these wonderful things with me. So these are the four key things that we're going to talk about today. We're going to start with a description of what is generative artificial intelligence, aka throughout the rest of this webinar, GAI. We're going to do a quick tour of how GAI is used. We're going to talk about US, EU, and beyond, and the laws and legal frameworks that apply, and some key takeaways. I want to start just by saying that everything in artificial intelligence is changing so quickly that almost the minute we finish our deck, it's out of date. And it is also a cross-functional, cross-practice, top-down, bottom-up compliance obligation, and let's call it a department within an organization. So we can't possibly cover everything. What we want to do today is get you familiar and give you some things to think about. As Ellen mentioned, some subsequent webinars will dig in, and we are delighted to receive questions from you. Truly, it helps us understand what people do and don't understand, and how we can be more helpful to all of you. So I'm Julia Jacobson, and Annetta, my colleague, is here with me, and I'll let her introduce herself in a moment. But we're going to start out with talking about what is generative AI. And we're going to focus on the AI part. So we're just providing this sort of description of how AI is defined under different laws. One of the biggest challenges has been, what is AI? Now, we all know machines can't really think, so it's not really intelligent in the way that humans are. It is artificial intelligence, but defining what AI is for purposes of regulatory compliance has defied many regulators and, in fact, many lawyers trying to figure out, is it AI or is it something else? So today we're using AI as a catch-all term to mean all of the things here. And Annetta, did the EU, are they closer to a definition now for EU law, or are we still?
That's hard to say. Yeah. Thank you, Julia. First of all, my name is Annette Demmel. I'm located in Germany, in Berlin. I will cover a little bit of the EU side here. Yeah, so the AI Act is highly under discussion over here. And also the definition part, of course. Currently, it's close to the OECD definition, but it is likely that there will be changes here and there. And just to mention that right at the beginning, although some people expected that the EU will come to an end and enact the EU AI Act at the end of the year, this is not so likely. So probably we'll have a code in between to regulate all this. So handing over back to you, Julia.
Thank you. And I just want to point out that the U.S. Federal Trade Commission has a very useful definition there, defined in many ways and often in broad terms. So just take that with you as we continue throughout the webinar. So what is generative AI? Here's a whole bunch of definitions from different places. The one commonality here is that we're talking about an algorithm that's trained on a very, very large data set that responds to prompts. So it's human-esque in that you ask it a question and it spits out an answer. And I think that that's a lot of what has triggered some of the concerns about AI across the world, that it has this human feel. But I think for our purposes, we're talking about a really big, really big training data set to train an algorithm to provide responses. What that means is that generative AI can be used in a whole bunch of different ways that we're going to talk about. Annetta, Alan, anything to add here about what GAI is?
I think that's well put.
All right, onward. So here are some examples. So according to Google Bard, this is what Google Bard is. So large language model is something that Alan will explain a little bit better in a moment. ChatGPT, perhaps the most famous one, since it exploded onto the scene last November. So this is what ChatGPT thinks it is. Again, here we are, prompts, output with a human-like. It's versus, I had somebody ask me one time, why is this different from Google, right? Just saying, hello, Google, find me a website about blank. It's the fact that it's put together and has this human feel. I think that's the distinguishing characteristic. Dolly, so these were the, let's call them the chat-like GAI. These are the, let's call them artistic-like GAI. This is Dolly, which is offered by the same OpenAI, the same business that offered us ChatGPT. Midjourney, again, here's a compare and contrast with Dolly right here. Again, these are what's out there on the market right now. And then here's some GAI lingo, and we're going to offer you this because one of the things that Alan and I learned during a presentation a few months ago is that people are really confused about the lingo, and that having just a few terms defined up front, we hope will make the rest of the webinar better. So Alan, I'm going to turn it over to Annetta and or you to talk about these. So Alan, you want to start?
Yeah, I think one of the most important things to think about is the data flows, the data in, the data out, and what the necessity of the machine learning is this training data. And that's the data used to train the AI model, which is categorized in order to allow the model to learn over time. So training data may be limited or ongoing, which can impact the credibility of the results. So some of these large language models, use massive training data from public sources or quasi-public sources, like things scraped off of the web. May or may not be accurate, and a lot of it may have been done years ago, so it may not be current, or may no longer be accurate because it's not current. Also, the training data set does not necessarily accurately represent the universe of the applicable data, then the credibility will also be impacted. You can also get bias as a result of the training data set. And there's been a lot of examples where we've gone back and looked at the bias that is inherent in the outputs, and it can be traced back to the biased nature of the data inputs. So part of one of the things that we'll talk about at some point is doing assessments to weed out bias and to improve credibility and accuracy. And then there's a lot of other issues, and I'll talk about them, about confidentiality, personal data rights, and intellectual property issues that are inherent in the data out and the data in. Another term that's worth knowing is neural networks. These are essentially a subset of machine learning, which use algorithms to learn as they're fed new data by developing predictions, measuring accuracy against reality, and adjusting the weights given to data sets to narrow the distance between prediction and reality. In other words, to improve accuracy and credibility, and that's really essential. What we don't have on here, but a term you should know, is hallucinations. And that we do, sorry. And those are basically incorrect outputs as a result of bad data in or bad processing of the data in. And I'll talk about a couple really embarrassing examples of those. And every time you pick up the news these days, you can see another lawsuit or sanctions against a lawyer or some other issue resulting from people relying on bad AI outputs that are simply inaccurate, or in other words, hallucinations. Annetta, you have some other terms for us?
Not so much to add, except that years ago I attended a conference and they showed a film there where three people were talking to each other. And at the end of the film, they told us that none of the stuff was real. So it was three people created by artificial intelligence, and the dialogue and the pictures were just not real, but you could not distinguish. And it was years ago. So it was really the first, I can call it shock that I faced with these things.
So voice cloning, deep fakes, they're all over the news right now. I liked this little voice cloning example from the Federal Trade Commission in one of their little consumer advice, things, alerts. I also recently heard about a really almost terrifying one where people were spoofing calls within homes and pretending like they were holding people's children's dogs, family members in within the home, and they were spoofing it to get money, and they wouldn't, said, don't leave the room you're in. It was just, just horrifying for the people that were subject to it, until of course everybody realizes it. So seeing may not be believing, as Annetta pointed out there. And I guess, picking up on some of what Alan said, these are kind of examples of some of the less pleasant outputs from generative AI tools.
And understanding these things is essential in developing a policy and a framework for use of AI in your company, and making sure that the benefits outweigh the harms, right? This is supposed to be a tool to make our lives easier and better, not to create more problems for us.
Or scare people. So how is GAI used? We thought it might be helpful just to give you some examples of the scope of generative AI in our everyday lives. I'll start here with consumers, digital assistants. I am sometimes tempted to check them out to see if they really could reply to my emails on my behalf. But, then again, we have those hallucinations and those mistakes, and, it's probably not worth it to try. I recently learned about a dating app that's using generative AI tools, both in terms of sort of the image recognition to give people scores for how they looked based on the photos they uploaded. Now you can imagine if somebody uploaded somebody else's photo, how might that might skew the score. And then the generative AI tool asks a series of questions and sort of produces the profile for the deity, I guess we'll call it. So, and then we have, we have artists. I don't know, Annetta, do you want to talk about some of these, or Alan, do you want to chime in on some of these concepts?
Yeah, for the artist one, we had recently a very good example. So a photographer submitted an artwork in a competition, and then he won. And after that, he refused to take the prize, but he revealed that this was created with AI, and he just wanted to test because the contest rules did not explicitly exclude the use of AI. So he wanted to show what is possible. And yeah, he made the whole story public. It was very interesting, was in the news. So that just one example. We will later on talk about copyright issues. Of course, can AI be the author of an artwork, or is this impossible? Or how much human contribution must be in an artwork, or in commands that you give to the AI to say that there is some kind of creative part. So this is very interesting. Another example in this regard is the employee sector. Very often now, you have the possibility, if you apply somewhere, you have the possibility to lead your interviews online. And sometimes already, not over here, I haven't seen it yet, but these interviews are led by bots. So this is no human being leading the interview. So the applicant is just facing a bot and talking to the bot. And also with questionnaires, employment questionnaires, they may be, or they can be created with AI, but this is somehow, of course, dangerous. So later on, we will talk about the legal regimes and what you need to pay attention to, but just being aware that you're not allowed, for example, in Germany, if you have an applicant interview, to ask the person if she is pregnant. This is not permissible in Germany, for example. And there are a lot of other questions that are not permissible. So if a questionnaire has been created with AI, there, of course, are some dangerous situations associated with that.
Yeah, so then like customer service is on here, and that's a good one. And you also have to sort of think about what's the use case. So a lot of companies are now using generative AI to do the first draft of a response to a customer inquiry or customer complaint. But it's reviewed by the humans, it's edited, it's perfected, and there's not really a lot of facts that need to be checking. That's relatively low risk. There's also AI-driven customer service chat bots. Now, if they've got really tight controls on them and they can only provide certain responses, then that's relatively low risk as well. Although I should note, in California, we have a bot disclosure law that you would have to disclose that the customer was interacting with artificial intelligence with a bot. But without limits and controls, the artificial intelligence might respond in a way that would be inappropriate. Research is another common. Students, lawyers, journalists. Just in this morning's news, there were two examples of this gone bad. A journalist used generative AI to do research, and there was a hallucination that suggested that this conservative talk show host had engaged in some improper behavior. He's now suing for defamation based on that. And lawyers subject to sanctions in New York because they use generative AI to draft a brief, and the AI included citations to cases that don't exist. So again, if you're going to use AI, there need to be logical constraints and safety checks around it.
one interesting one that I read about, which I know you all can read the paper also, but we're just trying to highlight how pervasive GAI is in our lives right now, was an idea that for sort of basic medical care, that a chat bot could diagnose and maybe perhaps eventually prescribe, probably not the really serious narcotics, but prescribe sort of simple, remedies. And I find that one particularly interesting because, as Alan noted, sometimes the training data sets are not super current. So can you imagine a training data set from 2019 that had never heard of COVID-19? So you can see where, again, safety concerns, Annetta's going to talk a little bit about that in the context of EU law, but doctors, and then Alan mentioned courts. I was at a conference next week. I've not independently verified the story that I'm about to tell you, but it did, I did find it very interesting. In a South American country, apparently a judge decided in a domestic dispute how to divide, that he didn't know how to divide the assets. So he asked ChatGPT to come up with a way to divide the assets, giving ChatGPT all the assets and asked ChatGPT to, essentially determine how to divide them. And he issued his opinion, and he made it very clear that he had used ChatGPT. And I'm told, again, I've not independently verified this, that a panel of judges looked at it and was like, that's a pretty good division of assets. So, there's the good side, potentially, hopefully eliminating some human bias, maybe. And then the bad side, as Alan pointed out, of citations of cases that don't in fact exist. So again, GAI is everywhere. So what laws apply? So Alan and I are going to give you a very quick tour of the US laws. And just to say again up front, we cannot possibly cover everything that there is to cover about generative AI in 50 minutes. This is intended to give you kind of a punch list of laws to consider. In particular, I think the intellectual property material that Alan's going to go over is particularly important in the context of generative AI. So, US regulatory landscape. Here are the ones that we're going to cover today. Consumer protection law will be Alan and me, copyright Alan, contract me, and privacy and data protection law will be everybody, because we are all privacy lawyers and part of Alan's privacy group. So FTC, so Alan and I are having a little role reversal here because he's really the FTC guru, but I wanted to just say consumer protection laws. They're always going to be emerging, rearing their ugly heads, so to speak, in generative AI. Yesterday, two senators raised these particular concerns in a letter to generative AI provider. So misuse and spam, fraud, malware, privacy violations, harassment, and other wrongdoing and harms in GAI systems. These are all the stuff that kind of consumer protection laws are intended to prevent against. The FTC has been urged to take a very close look at generative AI and has done so. For our purposes, we cited two of the FTC's recent writings on chat or GAI related from March and April. There are many more, but we're talking about unfair and deceptive trade practices. So this is primarily the business to consumer world, protecting consumers from deceptive trade practices, and I'll let Alan chime in again, and unfair, and borrowing from Alan's words, it has to do more good than harm. That's our unfairness. And deception, deep face, voice cloning, we talked a little bit about that. So I'm going to go on here and talk really quickly about the US states have these mini FTC acts. We haven't seen them be super aggressive in generative AI yet. But I expect that the states will get in the act just as they have done in the US in privacy laws. The one thing I think it's always really important to remember about the state consumer protection laws that they are often broader and they have much bigger teeth, so to speak. Here in Massachusetts, treble damages. If you did it, you had a knowing violation, and knowing means exactly what it sounds like. It's a matter of proof. But Chapter 93A in Massachusetts, treble damages makes these state consumer protection laws not to be ignored. Ellen, do you want to add anything quickly about consumer protection laws here?
Yeah, sure. So, the FTC uses Section 5, its deception and unfairness authority, where it is concerned with consumer harm regarding practices affecting commerce. And they don't need a particular statute about a particular practice. It's a really broad tool. When it comes to AI, they've come out and said, if you're making any representation or claims about AI, it needs to be non-deceptive, it needs to be substantiated. So if you're suggesting that it's more accurate than it is, or that something was created using AI when it wasn't, just because that sounds cool, those are things that they'll go after. The unfairness is really going to be more about harm, whether there's bias. They're really concerned about racial or economic bias that would affect vulnerable groups. One of the things I think is interesting, a lot of clients are asking, do I need to disclose that something is AI or something was created using AI? And that's unclear yet. Probably would be a best practice. As I said, if you're using AI or bot to actively communicate online with a customer in a way that relates to voting or the sale or service of goods or services, that has to be disclosed. That's the only statute that I'm aware of. In the EU, they're considering amending their code of practice on disinformation to require affirmative disclosure regarding AI or AI outputs. And there are a number of federal judges that have issued local orders that require disclosure if AI was used to create anything that's filed with the court. So that'll be an interesting one to keep an eye on, to see if it's deemed to be deception by omission not to disclose the use of AI.
So we were recently attended a conference in DC, and one of the FTC commissioners made a point of saying that generative AI is regulated, and that the fact that it's not been applied and that it's, as we noted in the beginning, unpredictable. We don't know what's coming next in terms of technology, generative AI. Isn't really an excuse. So in one of our key takeaways that Ned and I will talk about at the end, staying up to date on all of this stuff is going to be really important to avoiding some of the unfair and deceptive trade practice laws, because you may not understand the technology, but that isn't going to get you out of trouble. So back to the states, we'll continue on. These are two cases, and they're not new. I'm about a year old, but what we want to emphasize here is that AI technology providers have been required to destroy their algorithms and training sets the fruits of their labor, and in this case, the fruits of the deception, as noted in the Everalbum case, because they didn't do it the right way. They didn't collect the information in the right way. They didn't use it in the right way. So the point here is that if you are on the provider side versus the user side, paying very close attention to consumer protection laws is going to also protect your technology. And that's sort of the other side. I think it's also for users of generative AI and AI tools generally. It's important to do a little digging to find out, hey, has your chosen provider been subject to any of these regulatory inquiries? And to maybe consider that when you're negotiating your contract, which we'll talk about in a little bit. But again, getting it right is going to be really important to protecting your technology. I think that's what these two cases stand for. Alan, do you want to add anything here?
Well, I think the one thing that people ought to pay attention to is part of the remedies here were the destruction of the data and destruction of the algorithms. So, this is again back to assessments. If you don't get it right during the development stage, you may invest a lot of time and money ultimately to have to destroy everything you worked on.
Right, and Everalbum even did try to get an assessment and still had some problems related to violating consumer protection laws. So we'll move right along here because we have a lot to cover. Now I'm going to turn over to Alan to talk about copyright law in the US. And this, I think, arguably has received the most attention for generative AI. So Alan, take it away.
Yeah, this is really fascinating stuff for copyright geeks. But if you think about it, generative AI generates content, right? And that's the whole purpose of it. And content is subject to intellectual property protection. So I'm going to talk a little bit about the inputs and the outputs. Starting with the output, typically a brand wants to own the IP rights to the content it creates or commissions, and to ensure that its use does not infringe the rights of others. Both are challenges with generative AI. First, the US Copyright Act protects the exclusive rights for an original work of human authorship. So for instance, a photo taken by a monkey has been deemed incapable of copyright protection. The Copyright Office has been looking for applications where AI was used in the creation process. In a recent office action, it held that only the text selection and arrangement of AI-generated graphic novel comic content was protectable, and the images themselves were not, because they were not created by human artistic endeavor. This notwithstanding that the artist designed the prompts that generated the images and edited them. So the test is whether an instrument is merely assisting the human creator who does the actual creation, or if the technology itself conceives and executes even a first draft. The final edits are merely derivative of the non-human initial expression, and thus the underlying work is deemed authorless. So assuming you can get over not being able to own or protect the output if you distribute, display, or perform a derivative work of an underlying copyright protected work, which the AI was trained on, that may constitute copyright infringement, depending upon how much of the underlying work is in the derivative. So for instance, is an underlying character like if an underlying character like James Bond is used, and I refer everyone back to the well-known United Artists versus Honda Motor case, establishing that the mere attributes of a famous character could be subject to copyright infringement, and an ad that that incorporated those attributes could be infringing. So you can think about how AI images are often created. Create a James Bond-like character to showcase my new car could very easily have created that ad. And so then the real question is, okay, well, isn't it a fair use to use other people's work in a transformative way? And isn't transformation inherent in AI content generation? That's the really interesting issue here, and it's unresolved. Keep in mind that fair use is an affirmative defense, and the courts have been all over the place as to how to apply the multi-factor test. And one of the most important factors is the financial impact on the original author. Where fair use has been found, such as parody and criticism, courts have noted that the author would not seek to commercially parody or critique their own work, so there's no appropriation of the commercial opportunity. As will be demonstrated in a moment, copyright owners could financially benefit from the payment of fees to them for licensing their works as training data sets. Beyond copyright, worry about defamation and libel when the output of generative AI incorrectly attributes false and scandalous facts to a person, which could come out of a bad training data set. Lots of complaints coming out of generative AI, including the one I mentioned this morning, or that was all over the news this morning about the conservative talk show host who's now bringing a defamation case against a journalist. Then there are also your rights of confidentiality in your own proprietary data that's input. What are the terms of use related to the generative AI you're using? Are you giving up your rights by doing so? Most of these tools treat all the free public use as a conveyance of rights to them, whereas if you pay money, you can license a private instance where you can limit your input data to only your use and subject to confidentiality. So again, if you're going to use generative AI in the workplace, you either want to limit the data that's going in, or you want to get a private instance where you can protect the rights and confidentiality to that data going in. Now let's look at a couple of the cases. There are two class actions against GitHub alleging that its code generator called Copilot, which uses open source to train the AI, violates the terms of the applicable license agreements. Copyleft is not without restriction. People think open source means I can do anything I want to with it. Well, it doesn't necessarily. Among the typical license requirements that are in open source licenses is that the open source code to be copied must include attribution to the author and application of the license agreement to it and to the derivatives. The plaintiffs allege that this is not being done in violation of the open source licenses and GitHub's own terms of use, and that the removal of the notices and attribution and license notices that the AI is alleged to have done is a DMCA violation. There's a number of other claims. The one that I really like is the Getty Images and Anderson cases. They're rooted in copyright infringement for the mass scraping of unlicensed images to train the AI. The question is whether or not this is fair use. In addition to the appropriation of the commercial opportunity issue, another factor is how much of the underlying work is used, with the standard being that the use, if it's a fair use, should be limited to the least amount necessary to accomplish the transformation. An interesting fact alleged in the Getty cases is that Stability AI is really no more than a collage tool that is cutting or rearranging and repasting its copyright protected works, as opposed to something truly transformative. And to help illustrate that, they presented the court with numerous AI generated images that display as part of the new work the Getty Images watermarks or copyright notices from the underlying works. Here you can see it on this picture that was attached to the complaint. This is the kind of things that sort of judges have a hard time getting over. So it's going to be really interesting to see how this case develops. Julia, back to you.
Thank you. I'm going to do a kind of quick overview of some of the stuff that has come up in my helping to support clients engaging providers, and also a little bit from the provider perspective. But this is much more from the I want a generative AI tool for purpose for one of the use cases we already described. So questions: is open source software in use? Source of the training data, that's a big one. Source and how old is it, right? You can think in using that medical example again, if a medical assistant was trained before 2019, it's probably not going to recognize COVID. we don't expect that would happen, but just as an example. The IP rights to the inputs and outputs, as Alan just talked about, that's an important contractual term. For example, do you want to give IP rights to, if you're using a Dolly-like tool to create some artwork for an ad campaign? There's an example of that. The responsibility for the transparency for the end user, again, that's pretty important to think about when you are doing the provider, whether it's an employee, a patient, a student. How are you going to tell people what's going on? Honoring privacy choices. Alan and Annetta will dig into that. Reps and warranties. My personal favorite part of all contracts is what are you promising and how much are you willing to promise it? My experience is that generally speaking, the GAI providers say, we're offering you this really cool tool. It's as is. And of course, the business customer says, hey, you have to stand behind your technology. That's not fair. I think as this becomes more pervasive and as the tools proliferate, we'll see sort of more middling approach to the reps and warranties and some of the liability allocation. And then who's responsible for making sure things are accurate? These tools may be used for multiple purposes, and is it the provider's responsibility to make sure that the outputs are appropriate to the inputs when it might not know what the inputs are? Again, just trying to offer a little bit of the both sides here. It's complicated. I personally find it really fun, but I think most people do not. So I'm happy to talk about this more, but I just wanted to give you a quick punch list of things to think about. And the state privacy laws. I'm going to let Ellen just give a quick discussion of the state privacy laws, and then we're going to turn everything over to Annetta before we run out of time to hear all of her excellent content. So, Ellen, do you want to say anything about the state privacy laws?
Yeah, I think it's interesting that all of this new generation of privacy laws are looking at AI in a sense. It's usually in the context of what's so-called profiling or automated decision making, which is not really that relevant to the generative AI use cases that we've been talking about. Although you can certainly imagine a use case that might flow into that, and as part of that, assessments are required. So companies are going to start doing assessments for all sorts of high-risk data processing, including profiling, targeted advertising, processing of sensitive data. And that creates a natural venue and procedure, process, governance structure for assessing all types of AI, even if they don't fall into the category of profiling. And in fact, you won't know until you do an assessment if it falls into the category of profiling that would require the consent requirements. And then let's not forget also data subject rights, or as we call them in the US, consumer rights requests, right? To delete, forget, to access or copy. And all that data is now another database that needs to be searched, and what are the practicalities and viability of doing that. Annetta?
Oh, and also dark patterns. We can't forget our friends, the dark patterns under the state laws.
Good point.
Yeah. So, Annetta, we are going to turn over to you, and we are both going to go on mute and let you give us your keen insight on the EU regulatory landscape for GAI. So take it away.
Thank you. Happy to do so. Yeah, so for the EU, currently, we do not have any dedicated AI regulation. So what we are currently doing is similar to what we've heard right now for the US. We are applying general principles from various sectors of law, competition law, general contract law, privacy laws, of course, and product liability and so on. But the EU is quite active in bringing up the AI Act, and also coming along with that, an AI liability directive. The data protection law is already there, and we have the copyright law. I will talk a little bit more in details to that a little bit later on. And then we have upcoming legislation such as the NIS2 directive, which will probably also focus a little bit on these kind of developments. And we have already existing a product liability directive that is currently being supplemented with here and there with the new technological developments. Yeah, so we can go to the next slide. And here's what the EU is planning with regard to the AI regulation. First of all, a regulation on the EU level is something that applies directly in all member states, as opposed to a directive which has to be transformed into national laws. So whenever we have a regulation, such as the General Data Protection Regulation, it becomes a little bit easier, not meaning that the law is really in every corner fully harmonized, because these regulations also often have carved out some areas where they allow member states to have additional laws. But yeah, the regulation is intended, or probably will come into force 2023. I don't know if this will happen. Probably we will have to work with this upcoming EU AI code in the meantime. Maybe it will become 2025. I don't know. There's a lot of discussion around that. The one thing that currently is probably off the table, I would just take it first here, is an authorized AI representative. The EU intended to introduce an obligation for companies to appoint an authorized representative who should be personally liable for fault AI. So the question immediately was, who will cover that job? No one would do that, and no insurance would insure that kind of risk. So this seems to be off the table now, but you will never know. We will watch the developments. Yeah, when it will come into force, it will be the first AI regulation in the world if it is 2023. Otherwise, others will be faster, probably. The fines in there are quite high, so up to 30 million euro or 6% of the annual worldwide turnover. This is similar to the GDPR, where we have 2 or 4% of the annual worldwide turnover, which can be significant, as we have seen in the GDPR sector. Then, yeah, I will skip the definition part because this will change, and we talked about it in the beginning. Yeah, this regulation will take a risk-based approach. So it will have general rules, and it will categorize AI or AI systems into systems that are unacceptable, coming with risks that we do not want to have. So these are generally forbidden. As an example for that is AI that is created to manipulate human behavior or opinions or decisions. So this kind of AI is forbidden. Also, biometric real-time information for the purpose of law enforcement. So, for example, if you go through a station and your face is scanned, you're identified, and in that moment, someone is standing there and getting you. So these kind of systems probably will be forbidden, but I think there will be something in this area where they may changes, or I expect this to be. Then scoring with the purpose of treating people in a special social context will also be forbidden. So these are examples for high risk, for unacceptable acceptable risk AI that will be forbidden. Then we have the broad examples for higher risks AI. These are then listed in an annex to the planned regulation. Examples for that is, for example, I would call it normal biometric identification in the company context, or educational and vocational training systems. So these are considered, of course, to be high risk because it's so sensitive. So if you select people by using AI, if they have access to a certain university or to a certain course, or you choose what kind of content they are offered during their online studies, for example, and there's no human corrective measure behind that. This is really tricky, and this is highly regulated. Or another example would be creditworthiness, of course. So if you use AI in this context, you need to undergo a lot of measures to assess the risk, to document the risk. Then you need to under the current draft, this can all change. You need to establish a management practice internally to assess these risks and document the risks, and have a transparency system so that you can tell your employees and your customers of, I would say generally inputs and outputs and how the mechanism behind that works. And then there will be an incident reporting system that you need to establish, and there will be obligatory notification requirements for incidents. And of course, you need to have technical documentation in place. Quite detailed. Okay, so here you see one of these really major principles. You need to disclose things. This is one of the major principles of the EU AI regulation, and I expect that this will be the major one worldwide. So people need to know what are you doing and what are they interacting with an AI machine, or is your product built with AI with a significant effect on a person? And this is all about transparency. Okay, next slide. So along with the EU AI directive comes a liability directive. And this one is designed in a way that is fault-based, and it will cover it will give natural persons and also legal persons claims, and for fraud influencing the AI system that caused the damage. So this is the intent of this liability directive coming along with the AI directive. And as opposed to that, if you go to the next slide, we have the EU product liability directive. This is already in place, but it is in the remaking. This is strict liability, so no fraud-based. This is for products, and this is for individuals only. Currently, it is designed in a rather traditional way, I would say, but once it will be amended, it will also cover psychological damage and data loss, but it will not cover fundamental rights violations. So we really need this AI liability directive. So just a few quick words to the German and the EU copyright. We probably have the same issues as you have there over in the US, although the copyright system is a little bit different. But the question is, can software be an author of a text? Currently, probably not. And how can cases be handled if there is really a substantial intellectual contribution to the generated work? How is this treated? Then currently we have the right in the copyright that you can mine a text and use it, but it's only for scientific purposes. It's a very small right. And the question is, can we extend it? Should we extend this to make it workable for everyone, or should it be just restricted to scientific institutions? So this is under discussion now, and currently we can only resolve cases really on an individual basis. Just very quick, you can take a look at this slide. We will send around the slides. This is what happened over here. When ChatGPT came prominently in the news, you probably heard it, then the Italian regulator said, oh, better not use it, we will start an investigation. And then the UK announced that they will start an investigation on the use and the mechanism behind it. Then Italy just a little bit withdraw. So they asked for things to comply with. Then the EU announced that they will investigate. Spain did it, France did it, and so on. And then Germany at the end also announced with one of the data protection authorities to investigate. But currently we do not have, I would say, the one decision that says the use of ChatGPT is illegal under data protection aspects. We have all this discussion that Alan, you mentioned. Personal data, there must be a legal reason to use personal data. Do people have this legal reason? Do they have consent? Do they have another legal grounds to use personal data? Can data subjects be informed that their data have been used? And what about the results? Can I make data subject access rights and so on? So this is still all under discussion.
And here's just a quick, again, we're short on time, but here's some other jurisdictions that are looking at generative AI activity. I should also note that Canada has proposed a sort of more EU-like omnibus AI regulation. But these are just, you know, and again, the minute we do this, somebody else comes out and says something. So this is already out of date, but at least it gives you an idea of the global interest in generative AI. And we're going to get to the key takeaways because we hope that's what you really want. So I just want to start by saying one of the difficulties operating in an environment that doesn't have clear laws is figuring out what to do. And we offer these common principles to you as sort of a way to check and double check some of your plans with AI generally and generative AI in particular. We've talked about all these, you know, beneficial intelligence is one of my phrases, do no harm, you know, accountability. That's both internally and with your provider, companies' responsibility and the provider's responsibility. Transparency and explainability are uniquely important in generative AI, I think. Fairness and non-discrimination, maybe we could replace that with let's not have a lot of hallucinations, deep fakes, and voice cloning, but it's all wrapped up in that those same issues. Privacy, as we've already noted, and then safety and reliability. This is again kind of getting back to Alan's do more good than harm and some of what Annetta talked about with the EU Liability Act. So these are just some principles to keep in mind if you can't figure out what to do, which, you know, frankly, in a changing, and I'm talking hourly, I'm sure by the time we finish this webinar, we've gotten 5 new emails about some new development in AI. I mean, and that is not an exaggeration, by the way. And then, so we just want to flip quickly to some of these key takeaways for governance. So, of course, Annetta, you want to kind of kick off here?
Yeah, very quickly, you really need to watch out for the legal developments. So as Julie mentioned, the law is changing so quickly. So may appoint a person to watch what is applicable to what you're planning to do.
And then the policy, you know, figure out what to do, how to do it, and figuring out your use cases, what you plan to do with the generative AI, and monitor it and train users. This is not all that particularly different than anything else that happens in the workplace. Things can always be misused. People can, you know, misappropriate funds, or they can use their company car for improper purposes. It's just that the GAI, generative AI, is a little sneakier. And I think because of its human-like qualities, people don't, you know, think of it the same way as I'm, you know, using my car on a my company car for a personal vacation. you know, the IP issues Alan's covered really well, careful contracting. And then as Alan was talking about with assessments, I think it's also really important to document the risk decision-making process in real time. So you remember why you chose to do something that later may turn out to have been a really bad idea. You can't know. It's very difficult in this environment. Annetta, you want to talk quickly about some of the this third, the blue-gray bullet there?
Yes. So in the EU, especially in Germany, if you introduce AI-based software that employees can use in the company, so you grant a couple of employees a license and others not. This is subject to Works Council co-determination. In Germany, you need to sign an agreement. You need to reach an agreement with the Works Council who gets the license and who not, if you have established a Works Council in the company. Also, if you're using software that watches the behavior or performance of employees, and behavior is also if you have a system and you can see who logged in when. This is subject to Works Council co-determination in Germany, and also consultation in France and Italy and a couple of other countries. And sometimes you also need to involve the unions for that. So pay attention to that. Not only start to do it, but consult with Works Council.
I think this last bullet is the one that I feel, besides the contracting, I feel most, I feel is sort of the biggest thing that we can offer you today, is to stay up to date on all this stuff, or find somebody who will stay up to date, whether you're a general counsel, whether you're a technologist, whether you're just, you know, ordinary lawyer like us. Figuring out who's going to stay up to date is really important, because it changes, and managing risk in an environment like this is really hard, and it's going to require that you have the people who are actually using the technology and leadership sort of meeting together to sort out what to do. Are we going to allow our employees to use generative AI? And if so, how are we going to do it? You know, for example, do we want them writing memos to clients? Or are we okay with it as an idea? Or are we okay with it just for fun? And then we're just going to wrap up really quickly with some quick things about privacy and data protection, which I believe we've already discussed, but I'll let Alan and Annetta come up with one really big takeaway, and then we will get you on your merry way.
Yeah, I mean, I think we've covered this, and we're about at time. So I think I'll just sort of wrap up by saying, you know, generative AI is a cool toy. It very well may be a useful tool, but how that tool is used is going to depend upon context. And without a company policy and a framework for assessing risk and appropriate use, then it's just getting used without authorization and without any kind of governance around it. So that's what we as lawyers, in-house and outside counsel, need to be working with our business folks to develop.
Annetta, any final thoughts to share?
Yeah, in the EU, it's very much about transparency. Transparency is really key over here.
Great. So questions, we welcome them. Not just saying it, we really do. And we also want to thank you. Compliments of Dolly. Dolly created this. We asked for a little robot in a happy color. The prompt was a little robot in a happy color that indicates our gratitude. So that's what Dolly produced for us. So thank you all very much. We are grateful that you joined us today, and we will be sharing content, and there'll be some future webinars that we hope you'll attend.